Welcome to the NAM Academy, everyone, and to our presentation of Inside the Mind of a Mediator, Avoiding Impasse and Maximizing Outcomes in Mediation. You can send any questions that you might have during the program through the Q&A feature at the bottom of the Zoom dashboard. And with that, I will turn it over to Veronica Renta-Irwin, and she's the president of the Long Island Hispanic Bar Association. Veronica.
Thank you so much, Sharon. So welcome, everyone. Thank you, everyone, for joining us tonight. My name is Veronica Renta-Irwin. I am the president of the Long Island Hispanic Bar Association. So let me wish you all a happy Puerto Rican Heritage Month. I want to begin by thanking Sharon and everyone over at NAM for this absolutely wonderful partnership. It has been an amazing experience putting this together, and I actually look forward to being able to collaborate in the future. So thank you so much for that. Now tonight we have really the pleasure of having with us Susan Hernandez, who is going to be our presenter. She is a member of NAM's hearing officer panel. In 2022, she was voted as top 3 mediator in the New York Law Journal Best of survey. And in 2021, she was ranked the #1 mediator in the state. Her mediation experience includes a range of case types that includes personal injury, real property, partition contracts, employment discrimination, and sexual harassment matters. She is renowned for her advocacy, legal acumen, and insight, and is a staunch supporter of women's rights and diversity in the workplace, and frequently lectures on ways to establish procedures and policies to increase the appointment of women and minorities in the courtroom and as arbitrators and mediators in ADR. Really, it is such an absolute pleasure to have you. I am so looking forward to this program. So I will turn it over to you, Ms. Hernandez.
Well, thank you very much, Veronica. I'm very happy to be here tonight. And I hope that all of you find this program very helpful. Mediation is a very important topic to talk about. It's the future of our system. COVID was an amazing proponent of continuing and really helping mediation along. The fact that courts closed and we were able to continue to work and continue to make things happen for people and their cases was clutch during that time. Let's go to this program now and talk about maximizing outcomes when you go into a mediation process. And one of the questions that you might ask is, why should ADR industry be focused on diversity? This is not about filling quotas or doing anything of that nature. This is about representing a community that we serve. When we work in, right now we're working in a big city of New York, we in a big state. Every city in this state has a diversity, and we should really represent the people who we're serving. We aren't there yet. Unfortunately, because of societal reasons, the prominent person in mediation and arbitration is a white man. And the reality is that's not what our community is. That really came to light with the Jay-Z story, the fact that he brought a lawsuit because he felt that he wasn't properly represented, and the court agreed. So when you ask the question, why diversity? Because we need to have more women and we need to have more people of color in this industry if we are planning to have an impact on our communities. What is alternative dispute resolution? It is exactly what the words say. It's an alternative way to settle your disputes. There are different methods of alternative dispute resolutions. One is a mediation that's non-binding. You go in and you talk, and we have discussions about the benefits of resolving a case. Another is arbitration. Arbitration is when you go in, you present the case as if it were a trial. Your adversary presents their case, you give evidence, and at the end of the day, the arbitrator makes a decision that is binding and on all sides, and no one can walk away from. Many of you have been in arbitration circumstances. When should that be used? There are lots of times. Sometimes when there's a limited policy and you can't make a decision as to, or you can't get authorization to pay what the right number is, you give it over to an arbitrator and let them decide. Sometimes when the cost of a litigation will overtake the benefit or the value of the claim, you use an arbitration so that someone who's a third party can be a neutral party to say, this is the way it ought to go, and actually enforce that. Important points to remember about arbitration is that it's a binding process. And once you're in it, you can't get out of it. And you have to be able to have confidence that no matter what the arbitrator decides, you'll be able to live with it. It works because it actually resolves cases. And that's really important. Mediation is another form of ADR. And what's mediation? Mediation is exactly what the word connotes. You go into a meeting and you give them your point of view. Your adversary gives their point of view, and the mediator then has discussions with each side about which is what the risks are, what the benefits are, can talk about the strengths of your case, but really when you go in to talk to each of the parties, you really should focus on why it's important to settle that case. An important point about mediation is that it's not a binding circumstance. You can actually have a mediation, and you can disagree with the mediator, and you can disagree with the other side. And it works because many times you need another voice of reason to talk to your client, whether you're the plaintiff or the defendant. You sometimes need that other voice saying, hey, this case has risk and you should resolve it. And I find that it works a lot. What to expect at your first mediation? You should expect to have someone who is cordial, someone who is happy to work with you, someone who is willing to talk to you and to your clients, and be able to have a discussion with you about the strengths and the risks of your case, and to be able to verbalize why it's a good idea to resolve it. You'll have an adversary there who you can't always tell what to expect from an adversary. And sometimes I really must admit, you don't get what you think you'll get. But by and large, you should be having people who are willing to come in and talk in a very civil manner and discuss the benefits of resolving a case. Benefits of early mediation. They are obvious. Disputes are resolved once and for all. They can be done privately. There are lots of times when you're representing a party that has a big impact on a community, a big presence, and they may not want everyone to know about every trip and fall that happens in their establishment, or every accident that their trucks are involved in. And this way, when you go to mediation, you can do that in a private way. The same goes for the plaintiff. Your plaintiff may not want the world to know that they won a $33 million lawsuit. So when you come into mediation, it can be done privately. Expeditious, very, very expeditious as compared to what the court system looks like now. The unfortunate reality is that COVID really put a real damper on our court system. There are places like Brooklyn that lost multiple judges. I think there were 4 judges that died in Brooklyn as a result of COVID. You can understand why judges are a little hesitant to go into a courtroom with a jury panel, with lawyers who are speaking to and at them, with witnesses and stenographers. It's sometimes a crowd in a very small space. So the result of that is that courts have really put a pause on the trials, the manner in which they did trials before. So now instead of conducting 5 or 10 trials at a time, maybe the court will do 3 trials at a time in an effort to have people spread out, in an effort to not use the really cramped courtrooms. The result of all that doesn't stop the claims coming into court. And it doesn't stop all of the people who are involved in actively suing. And so what happens is that the courts get really backed up, and that's what they are right now. You've seen that. Flexibility is also another very good benefit of mediation. When you have a mediation, it's not like a trial that you are at the whim of the court when they say you need to be ready. Instead, the parties decide when they are ready to come and start talking about it. They schedule the time, the day, the location, and they even select the mediator to address the specific needs of their case. Next slide is speak to your mediator early and often. Well, I am definitely not advocating that you should call me to chat and try to convince me about the value of your case before we actually mediate it. However, what is a good idea is to let a mediator know, hey, we have a case coming on this day that is going to require this, that, and the other. For example, I had a person let me know with a little bit of a advance notice that their client was very difficult, and it would require me to sit and talk to the client. Excellent, excellent heads up. I go into the mediation knowing that I address those issues right away. Another, actually today I had a case that it was such an explosive case. It was such an emotionally charged case that the parties couldn't be in the same room, and their lawyers couldn't be in the same room together at the same time. Good information to have in advance. As soon as we opened that mediation, and that was a virtual one, I immediately set up rooms. I immediately ushered everyone into their respective rooms, and I avoided the circumstance of having lawyers or clients scream at one another in a common session when we're here to make amends, when we're here to compromise and have a resolution. The topics that you can call and talk to a mediator about in advance can range from procedural to substantive overviews of the facts of your case. And as I said, it allows us to prepare and to address the issues immediately. Trust your mediator. That's a big one. If you don't trust your mediator, the chances are that you're putting out some kind of a feeler like, I'm negotiating the case with you first and then with my adversary. That's not a great position to be in. When I negotiate cases on behalf of clients, I like them to know that they can trust me. There are things that you might need and want for me to know that will help and aid me in getting to a resolution on your case. it's a good idea to have that trust with your mediator. We're going to talk about submissions. Submissions help a lot. I'll talk more about submissions later, but with a good submission, the mediator is right on the case, right on everything at the outset. And that's important for a good mediation. Know before you go. This is a big one, and this is a real important one. When you have issues on your case, it's important for you to share those with your adversary before you get to the mediation. The first bullet is a change in the demand or offer previously exchanged. That's a pet peeve of mine. It's really debilitating to have a case that comes in for a mediation. You sometimes have multiple parties, 8 or 9 people. If you have a large case, let's call it a construction case, you might have the owner of the building's representative, the construction's representative, the construction company's representative. You might have the insurance company. You might have other professionals there that are there to help aid a resolution. If you are changing things on the eve of a mediation, all of these folks don't have a chance to get on the same page before your mediation. It becomes impossible to effectively mediate a case like that. So you really need to give these folks a heads up as to what to expect in the mediation before you get there. If you have new evidence, I really find it troubling when I have a case on and someone will tell me, well, we have video of the plaintiff doing all the terrible things that he says he couldn't do. And I say, well, did you exchange the video? No, and we don't want you to share it. Well, then how do you want that to help? What's the purpose of even bringing it up? If you haven't shared it, and I can't tell them this, you have a problem, folks. How do you expect for anyone to be able to use that information to help you? They can't. So that kind of things should be exchanged and shared prior to coming to a mediation. Who's in attendance at a mediation? Well, who should be there is everyone who has a say in the resolution. If you have a client that needs to be consulted every round, that client should be in the mediation, because it really puts a damper on everything when it takes 40 minutes for you to respond to an offer. These are things that should be, now I'm not saying that there aren't some offers that take time. That's true. But you can't have a circumstance where people are being consulted for every little move and they're not in the meeting. That becomes problematic. Insurance coverage amounts and any issues that involve hampering of being able to extend the insurance amounts that you exchange, that needs to be told to the people right up front and foremost. I mean, that has to be one of the first things that you talk about. Now, I mentioned before brief. Sometimes people get crazy about their briefs and they feel like it's homework. They feel like it's a legal brief from law school. That's not what it is. And I'll tell you right now, I think if you spoke to all of my colleagues, they would all tell you that the best brief is a brief, okay, is one that gets right to the point. I don't need 7 EBT transcripts. In fact, you don't want to pay me what it costs for me to sit down and read 7 or 2 EBT complete transcripts. That's a waste of time and money. What you should do is, if there is something in the EBT that's important to the case, you should say in your brief at the deposition, I'll use plaintiff for the sake of this example, the plaintiff testified that blah, blah, blah. That's noted on page 7 of the plaintiff's CBT transcript. Perfect. That tells me it's there. If you think there's going to be a problem with the words and how it was described, then just put in the 4 or 5 questions that you're referring to. Put them in word for word. Question, answer, question, answer. That's easy to read, easy to digest, and easy to understand. If you're going to give me a whole deposition transcript, I can assure you that the likelihood is that I will not read it. And I'll be asking you, what is it in this deposition that was important that you gave me the whole transcript? You should be able to digest the importance of a transcript in a paragraph or 2. The brief shouldn't be something that causes you angst and causes you hours of research and all of that stuff, because you should know your case. You should be able to say, I represent a 32-year-old woman who tripped and fell on a public sidewalk that's on West 12th Street. She fell because of a raised sidewalk flag. The sidewalk was raised about 2.5 inches. Here's the picture. And she had a comminuted fracture of the tibia. That was, she went by ambulance to St. Jude's. She had it externally fixed, and then they took a look at it a week later and they gave her an open reduction internal fixation. It was an in and out procedure. That should be the kind of description you're giving me about the case. She's a working woman. She was out of work for 3 months. She lost this much. This is the demand. These are the liens. It's the information I need to help you get the case settled is very specific and it's not your whole entire file. It doesn't help to give the summons and complaint, the bill of particulars, the EBT. You can say all of that in 2 pages max and make it much clearer and much more helpful for a mediator. A lot of times exchanging the brief with your adversary could be an advantage, but sometimes not. Sometimes what you're exchanging, what you're giving to me is information that the adversary already has, but you want to put your spin on it. And if that's the case, then you keep it confidential. But be prepared then to talk about it all when you come and you start your opening statement. If you choose not to exchange a brief, you should mark it confidential just in case there's something in there that you don't want to have shared. I always, even if I know every single thing about a case, I will ask the lawyers, do you want to tell me about your case? Do you want to tell me about the claims that you're making? And it's not because I don't know about them. It's because I don't want to say I know if your brief was a confidential brief. Here's more about crafting the mediation brief. Submit an accurate, brief, and clear summary of your position. You should address the procedural status of the case. Sometimes, if a case is very early on, that will make a difference on how amenable the parties are to resolving the case. Sometimes it will also make a difference in how much they're willing to pay you. Because if they're going to have a 3.5-year wait to get to a trial, and if it's going to cost you another $30,000 to get this case on the road, maybe you'll be in a better position to negotiate on the money. As I said, avoiding redundancy, less is more, is always key. Attaching exhibits that are critical to your case is a good idea. If you don't have them attached to your brief, at least have them readily available so you can show them to me at the time of a mediation. If we're virtual, you could share a screen when we're in private session, and I could look at all the photographs that you didn't give me. That would be fine. I say submit the brief well in advance, but in reality with me, you could give it to me the day before and I'll be sure to read it, because I like to read my briefs right before, the day before I have my mediations. I make my notes, I have my briefs ready to go, and I prefer that rather than reading them a week in advance. And the reason for that is because if I read them a week ago, I will then sit on 12, 15, 25 other cases, and the details get fuzzy. Opening statements. I do have people who will pass up an opening statement. I have people that I know never make an opening statement, and that's fine. But it's an opportunity for you to put your position out there. It's an opportunity for you to have the other side hear a preview of what they might expect should this case not resolve. It's an opportunity for them to say, wow, maybe this does behoove me to get it done. It's also an opportunity, if you have a case and your adversary is coming in with an adjuster, let's say, I could bet you dollars to donuts that defense counsel has already told the adjuster all of the problems with the case from your point of view. Having you reaffirm those as a plaintiff's lawyer coming into a mediation, having you reaffirm all of those problems and risks that they have is just by human nature. It just solidifies what everybody was thinking. So it's a good idea to make a concise, non-argumentative opening statement. Let's go on to the next one. The absence of decision makers. Yeah, we covered that a little bit. That's a hugely problematic issue. If the clients are not available and they need to be in on the decision making, then we're wasting time. You come into a mediation, and if you needed to have an adjuster available and they're not there, or if you needed to have a plaintiff available and they're not there, then what are we doing? We could be sitting on a subway, taking a ride uptown, chatting about a case, because that's what we would wind up doing. Let's see, the logistical hurdles and delay in communication. Yeah, they do. I had a case today where there was a client intimately involved in the negotiation. Unfortunately, the client was not present, not virtually or physically. And I was very frustrated because I felt that everybody else was there. People took time from their very busy schedules to come and sit on this meeting. And you're going to tell me that your client didn't have the wherewithal to sit down and pick up a computer and join a meeting. And yet that person has the right to say yay or nay when we're talking about money. What's the impetus? What's the desire to even talk? It becomes problematic. So everyone should be there. My resolution, get your guy on the phone. I want to talk to him. And we did, and we settled the case. Wearing trial blinders. I never recommend, I think when you mediate your cases early and you have them fully briefed, you have much greater chance of resolving the case than if you wait till the eve of trial. On the eve of trial, you have taken out so many factors that can affect a resolution that it just really doesn't help. When you're at the eve of trial, first of all, trial lawyers have a tendency to be very focused and not be willing to look at the other side, because when they go into trial, their aim is to search and destroy, search and destroy, search and destroy. You're now asking them to have a much broader range when they're coming into mediation. The reality is that coming in with trial blinders, as I call it, coming in only thinking of that trial is a real problem. You need to have a meaningful discussion about all of the circumstances, not just a trial. That's the reason why you come to mediation, to avoid a trial. Acknowledging the weakness in a mediation. That's something that usually most lawyers will do in a private session. I've had wonderful results with lawyers who come in and first talk about the weaknesses in the case. I have a client that has had a troublesome course of events. They were in 3 accidents in a spate of 6 months. We are here on the last of those 3 accidents. And while I recognize that that might be a problem, I'm going to tell you why it's important. And I'm going to tell you why this case is not just an extension of the other 2. And I'm going to tell you why. And you, therefore, you kind of take the wind out of the sail of your opponent, who's all ready to say, are you kidding me? This is the 3rd of 3 accidents. You can sometimes have a lot more results if you come in and you acknowledge the weaknesses. Also, because you are selling something, you want people to believe you. You want people to buy what you're selling. And if you come in and immediately acknowledge that what you're selling is not perfection, you disarm people, and the whole defense kind of is a little bit less defensive, if you will. Or alternatively, the offense is a little less offensive. If you're constantly defending the weak points, then the focus becomes the weak points. If you come in and you say, this is the circumstance, and notwithstanding that, we have a strong case because of these other circumstances, then you are putting the focus on the strengths of your case, not on the weaknesses. That's why it's important to acknowledge these weaknesses. Let's go to the next slide. Overcoming an impasse, emotion and anxiety. That's most of the times when we ask the decision makers to come. Sometimes those are the clients. When you have a client in, sometimes they really need to just be heard. And in being heard, that could be met with an extreme amount of emotion and anxiety. As a mediator, I find that I really must be receptive to a client, to having a client tell their story. I need to allow the client to feel heard. By the way, this ties in to the diversity part, okay? And I'll tell you why. I am a woman. I am a Puerto Rican woman. There are an awful lot of Hispanic men and women who are litigants and come in for mediations. I have heard many more times than once or twice how wonderful it was to be able to speak with someone who could A, speak in their language, who can B, understand the culture, understand the person, and C, who look a little like them, who can identify with them. That's exceedingly important, because people who want to be heard want to feel like they're being understood. And you can't be understood if you're dealing with someone who is just light years in difference from you. So it's important when you're dealing with a mediation to address the emotional, psychological component of the mediation, as important as it is to deal with the legal issues. I can tell you, and it happened just this afternoon. I told you today I had 4 different mediations. 3 of them were exceedingly difficult. One of them was easy peasy. The exceedingly difficult ones, one of them was not even the client, the husband of the client was in the mediation running the show. And what did that mean? That meant that he was highly charged. He was going to go in and show everybody how important he was and how effective he was going to be. And you know what was most disarming to him was the fact that immediately I gave him props. You poor thing, how aggrieved you are. Tell me how aggrieved you are. And let him say everything he wanted to say. Once he said it, I had an opportunity to talk to him. And I had an opportunity to make him listen. And you know what? We got the case resolved because he came around to a different point of view. And that's only because he really needed to release his steam, release his stress about the circumstance. I acknowledged the stress. I acknowledged the discomfort. And then I went on to what can we do to make this better? And that's how we did it. I got to tell you, sometimes I feel like a social worker or a psychologist in what I'm doing. It's not only a knowledge of the law, it's sometimes even a knowledge of human nature and how to deal with people that makes for a very successful mediation. Yep, this is what I'm talking about. The next slide. Clients and their counsel need the opportunity to vent and complain. They have to get things off their chest. If they don't, they feel as if they never had a say in the circumstance. If they don't have a say in it, they're not willing to really compromise all that much. However, when you do have people getting all their emotions off their chest, there's also a need to keep things in perspective, keep things stable. You don't want somebody going off the deep end and screaming at another person or crying uncontrollably so they can't think straight about their case. You want them to be able to vent, but keep control. And that's an interesting and important medium to have. Overcoming an impasse. Well, I come to this space quite a lot. People sometimes come in and they are so geared for a fight that they come to an immediate impasse. And when that happens, I really have to be super patient. I have to be super understanding of why they're coming in the way they're coming in. And I have to talk them off the ledge. Sometimes I have people who are very willing to resolve a problem, but the system is not made for the resolution at that time. For example, sometimes I'll have a plaintiff's counsel and a defense counsel who can come to an agreement about the value of the case. And they can agree on the terms. But the problem is one or the other can't get their client to agree. Well, that's when my role becomes really important, because then it's really up to me to help them get their clients to come around to being able to see the benefit of a resolution. I do that a lot. Sometimes, it's interesting. The most oftentimes that I get that problem is when you have a self-insured or a uninsured person who's coming in. They have to understand the impact that a judgment could potentially have on them. They have to understand that by not resolving the case, they're not getting out of the problem. They stay in this problem. And they may even spend more money. You need to be able to get down to people's level and talk to them about the real nuts and bolts of the circumstance, of the lawsuit, of the financials, of the law, and of the system. And it should be done in a very non-judgmental way, and just an objective assessment of what's to come. I really do find that I've been able to get that across to people. Just today, I'm telling you about today I could have like 15 different examples just today. I had an adjuster who just made a decision that they would not pay X plus 1. They would pay up to X, but not X plus 1. And X wouldn't do it. They needed X plus 50. And I couldn't get that adjuster to change her mind. So I said, okay, I respect your opinion. I said, it's unfortunate that we were here with everybody involved and we couldn't get this done. And I'm sorry that it was not a more effective mediation session. And, you know, once I started saying all that, then she started backing off and she said, well, what do you think is going to happen at trial? And I stepped back and I said, you want me to tell you really what I think? And she said, yeah. I said, I think you're going to get sunk. I think you're going to wind up getting, I think you have a real risk of having a judgment that's far in excess of the numbers we're talking about today. Why? She says. I told her why. When I told her why, it was like, click, something happened. And she said, okay, wait, let's just keep talking then. And when I was all ready to say to the plaintiff, that's it, we're done. Instead, I said, hang on, we're going to talk some more. And yes, we got that case resolved. Let's see the next. Last minute surprises. I love surprises, but not in a mediation. Last minute surprises. What are some examples? Oh, I know a good example is that there's a humongous lien on the case that nobody knew about. So, you know, here you are thinking of a case and the value of a case and what you need to get it resolved. And all of a sudden you learn that you have a lien that's probably half of what the demand is. That becomes problematic. That's not a surprise we want to hear. Conditions. I always ask people, if you have conditions, let me know what they are at the beginning, at the outset. We put the conditions out there from the very first offer. Hey, just so you know, this is going to require a confidential non-disparagement, and they're not going to be able to pay until, 60 days after receipt of closing documents. If there's a problem, we need to know that now, because all of the offers will be with that condition in mind. This avoids getting to a number and then saying, oh, and by the way, I need 60 days instead of the traditional 21 days. That becomes problematic because maybe the plaintiff lawyer got his client to agree to some money because he said, look, you're going to get it in 3 weeks. You're not going to get it in. You don't have to wait a long time. So don't bring last minute surprises to a mediation unless it's cookies or cupcakes, you know. Well, I guess that's the end of our program here, but I can tell you that the reality is that in mediation, attitude is exceedingly important. Coming into a mediation process with a view to compromise and to talk and to listen is of utmost importance. If you're coming into the mediation process just to tell them what you're going to do to them when you get to trial to scare them into submission, that's not going to work, because chances are these people have done it before. And I got to tell you, I deal with a lot of heavy hitters in the state of New York. and also in the state of New Jersey, by the way. And I'll tell you right now, my biggest threats are the guys who come in, the guys and the women who come in with the softest voices, the most modulated tones, never raise their voice. They don't have to. They're exceedingly effective, just as they are. And if you utilize those skills, you find that your mediation will be as successful. Thank you very much for listening.
Susan, excuse me, Susan, before we let you go, there are a number of questions. If you wouldn't mind just taking a look at the Q&A at the bottom of your screen.
I won't
You
mind.
can't read it, then I can read them to you.
Well, I have one question here. It's in mediation. Should submissions be served on opposing parties, or are they only provided to the mediator? That's a good question. That question it depends on what you have. If you have a lot of opinions in your submission, if you have your trial tactics are being shared with the mediator in your submission, then keep them confidential. You don't really want that to be out there, and give them a heads up as to what to prepare for if the case doesn't get resolved. There's no problem having a confidential submission. That confidential submission is then used as a tool to share with the mediator what you want the mediator to know going into the mediation. If, however, you want to have a submission that is really going to be utilized by the defense attorney or the plaintiff's attorney to help them convince their client, then exchange it with the other side. Keep your trial tactics to yourself. Next question is, when the mediator learns about weaknesses in one party's case from the adversary, who wants to keep that information, or who wants to keep that information confidential? What can the mediator do with that information? Not much. If you're giving me information that helps your side, I can't keep it confidential and use it. But what I do is I will keep it confidential, the details of your information, but I'll say to you, look, at least can I explain to them that this and that and the other may occur? And usually they say, yeah, you can. And then I could go ahead and tell them about that. But you can't share confidential information if you've been asked to keep it confidential, okay? Approximately what percentage of time does an attorney share their brief with their adversary? I would say the overwhelming majority of people that give me briefs mark them confidential. Probably about, maybe it's 30–70% that will exchange them, 30 being the ones that exchange, 70 being the ones that don't. Let's see. How do you tackle purposeful anchoring? Half of a ridiculous demand is still a ridiculous demand. I am a very, very clear spoken woman. I rarely say something that I don't absolutely mean. When I have a ridiculous demand, when half of it is still a ridiculous demand, I say to them, you have a lot of room to move. Your numbers aren't even within reach of a sustainable, or your number tops the outliers in sustainability. And if that's where you want to be, then prepare yourself for a trial, because no one comes to a mediation to pay sustainable values. I talk to them. I talk to them. I talk and talk and then talk some more. That's how I deal with that. Thank you for your helpful presentation. Thank you. Thank you for coming.
Thank you for joining us.
Yes. Is mediation vastly different from yeah, absolutely. Mediation, you're here to talk. We're here to talk, to explore a resolution. In arbitration, you're going to get a resolution. And it may not be the one you want. You're going to get a resolution. So yes, the rules differ vastly because of the way they're done. It's like talking about, it's a comparison of having a conference in the court as opposed to a summary judgment, a summary jury trial. I have one here. If you have a large law firm on the other side, should you be concerned that the mediator may be more favorable to the other side, since the mediator may be looking for future work from the other side? I have a lot of people who come to me. Actually, I have so many people who come to me from all different areas. But I have a lot of people who come to me repeatedly because they are people who have a lot of business, and they are usually one person in the firm will handle all mediations. I feel no pressure I personally feel no pressure to kowtow to anyone. Thank God, let me knock on wood, I have been very busy. Every single day I am booked. I have free time when somebody adjourns a case. That's when I have free time. Today, I worked from 9 o'clock this morning till right about now I've been sitting at this desk from 9 in the morning till 5 in the afternoon. I was on mediations. Not one free moment, not one time where I had 10 minutes between mediations. I overlapped every single one. I had one of the people say to me, I just didn't feel you were on my side today, and I like using you, but I didn't feel you were on my side. And I said, well, I'm glad you felt that, because you should never feel that I'm on your side. I'm a neutral. I'm here to settle a case, but I'm not here to be your adversary, your advocate. That's really important to keep in mind. I can only tell you that when it comes to me and also other of my colleagues, because we do talk, if someone is not happy about the circumstance, there are a lot of good mediators at NAM. You have a wonderful array of choices. I don't kowtow to the business. First of all, I don't schedule my business. So I don't get calls from the client saying, we want to schedule a case with you or not. That goes through the scheduling department. That goes through the sales department. I don't even get to know who selected me and who didn't. People just show up. So the answer to that is, I wouldn't be terribly concerned about that. It's great to see you too, John. How do you manage evaluating candidly without losing the appearance of neutrality? I'm a neutral, but I am an honest neutral. If I think, like today, when the lady told me, what do you think is going to happen with my case when we go to trial? I said, I think you're going to lose. I think you're going to lose more money than we could settle the case for today. I think you have that big risk. Is there a possibility you'll win? It was really a case that needed to be resolved. And I was very, very candid with her. And I don't think I lost the appearance of being neutral. I didn't say it in front of the other side, giving them validation. I said it to her. It's as if you say to me, hey, does this dress look good on me? And I say, it looks good, but maybe it's got a big stain on the back. Did you know that? I'm being candid with you without being denigrating you or anything like that. Let's see here. Okay. Now that we are 3 years in post-COVID, how effective do you find? Oh, I find that virtual mediations are very effective. I will tell you right now, I mediated 4, 8, 12, 15 cases this week and settled all but one. The one that I didn't settle, we knew in the first 10 minutes it wasn't going to resolve because there were issues on that case. So virtual mediations are very effective. This is the wave of the future. People are not needing to schlep into a different city, to sit in an office, doing the same thing I'm doing on a virtual meeting. You just don't need to do that anymore. There are cases that require that. For those cases, we go in person, but virtuals are exceedingly effective. Ana Cabrera, thank you. Gracias a ti. Okay, I've used your services in your past and resolved. Oh, yes, thank you, Chris. Thanks for saying that. Do you feel that mediation is more effective in person versus remote? No, I don't. I feel that virtual is as effective, and sometimes more so because you could get more people involved in the meeting. I'm not seeing most of the attendee questions. Great presentation, and I agree the need for diversity. Yes. Okay, that sounds like a wonderful thing. And here's someone else who said, thank you for a great program. I'm curious to how you deal with the, oh, I almost forgot one more thing, party, namely someone who agrees on terms, but is just about to sign off. I accuse your person of negotiating bad faith. No, I never accuse anybody, but what I do is I say, you know, it's a toughie now to start, you know, we've already created the wheel and now you want to add some more spokes on it. It's a little difficult to do that. I try to keep people from doing that. I try to tell them to continue to talk and communicate and maybe add this to their closing documents. But I try not to make it shut down a mediation. How do you become a mediator? I really wanted to be a mediator many years before I actually became a mediator. And I didn't have the opportunity because I really didn't know how to become a mediator. But I will tell you, the best thing you do is you make a name for yourself in whatever area of law you're in. You get a name for yourself, people start to know you, and you should negotiate. You should negotiate as much as you can. And when you do, you contact one of the companies and you say, hey, I've been doing this for this many years. I have this and that goes into my favor and helps. And hopefully you'll get a job. I hope if you do that I get to see you because you're a woman, and I don't know if you're a woman of color, but a woman is just as well, because there's really a shortage of effective women in mediation. Are the signature signed? Okay, you just
I'll answer any administrative questions.
okay. All right, so I think that's it. No, what type of cases are not suitable for mediation? I haven't met one. How about that? I guess the one that's not suitable for mediation is the one that the client, be it defense or plaintiff, says, I will never get to this number or that number, and it's a reasonable number. I want $10 million in my pocket, or bust. That may not be the best case for a mediation. Do you ever have a concern about your personal media affecting the likelihood of being selected? You mean like Facebook, I guess, or something like that. I try to be very circumspect in my Facebook and my social media presence. I have 3 kids, so most of my stuff is about my kids. I try not to be too forceful. Sometimes, and especially in the recent past, there have been times when I felt it was important to take a stand on a political situation in social media. And I don't have a concern about that, because what you see with me is what you get. And if that becomes problematic, then perhaps I'm not the best person for you to mediate in front of. And those kinds of things you should know right offhand. I wouldn't want to find out as a party that my mediator is someone who hates people like me, if I'm going to mediate in front of them, you know. And I'm being facetious, and I'm being very simple, but I don't have a concern about that. I have an adjuster who prefers in-person mediation. Yes, NAM is absolutely doing in-person mediations. I am not currently doing in-person. I will do an in-person when it's an all-day affair. I don't do an in-person for a 1 or 2 hour because it's just too disruptive. I have 5 virtual conferences and then the one in person. And it's too disruptive to spend an entire day in the city doing what I do in my home office, just for one short case. But yes, there are many other mediators at NAM who are doing. Hey, did I have to press the button answer live on these questions?
No, don't worry about it.
Oh.
It's okay.
Boy, am I glad.
Everyone can hear you.
All righty. So I hope that answers all your questions. Oops, no, there are more questions. What's the difference between court-ordered mediations and those initiated by the parties? Well, if you know me, you know that I was a court mediator, and I'll tell you what the difference is. In court, people have to come to you. So they come to you, they come unprepared, they come without the authority that's needed, they come with the huffing and the puffing. They don't come with the desire to really work to getting this case resolved. When they are here in at NAM, and they have booked me 3 weeks in advance, and they have paid for a session in mediation, they're coming to settle a case. They're coming to make a real honest to goodness attempt to get a case done. And the likelihood is you'll have the people who are necessary there. You'll have them open to suggestions and open to a discussion. That's the major difference. Besides which, I have 2 hours to spend with people in a mediation at NAM, minimally 2 hours. Sometimes I have 4 hours, sometimes I have 6. In a court-ordered mediation, you might have 10 minutes. What do you want? How much do you have? Okay, no, okay, all right, goodbye, get out of here. They just don't have the manpower, the time to spend. Today, I spend my day on 4 cases. When I was up in the Bronx doing cases, I had a caseload of, could have been 65 cases on my calendar. And I could have settled, my aim was always to settle 15 cases a day. Or I'm not sure if it was 15 or 5, whatever it was. It was a lofty ideal, and I usually got them. But when I came and said, wow, I can only do 4 cases a day, that's awesome. That's the difference between court and private mediation. So let's see if there are any other questions before I say no more questions, and there is. When an opposing party seems resolute to avoid concession settlement of any kind and insists on their lack of liability whatsoever, what other areas do you focus on to still try to get the hearing trial value out of the mediation? Well, that's easy. If they're absolutely insisting they're going to win, I say, why? How? Tell me, how are you going to go about doing this? Why is it that you think this case is not worth this amount of money? Let's take a look at what the jury's going to consider. They're going to consider the blackboardable numbers. What are those numbers? Let's write them down. What about pain and suffering? Do you think a jury is going to consider this to be a painful injury? And do you think that the fact that this person spent 10 days in a hospital might be considered? Let me ask you something. Have you ever spent any time in the hospital? Do you know what it's like not to sleep, a full night's sleep at a hospital, because all night long lights are on, there's noise, there are people coming in and out of rooms. If you don't have the pleasure of being in a private room, you might have somebody in the next bed moaning. What's the value to that? Do you realize that people will focus on that? That's how you get people. You start trying to open their minds to things that they have been closed about. And hopefully you're able to get them to at least concede some things. And if you are, then sometimes you can even get a resolution out of it. Okay. I think I've answered all the questions. I'm just going down the line, Sharon. So if there's other questions,
Like if anyone else has any questions, Susan's email is at the end of the PowerPoint, so you can feel free to either email her directly or you can email me and I'll pass it on to her.
yes, that would be fine.
Thank you so much for presenting, Susan.
You're
Veronica,
very
thank you
welcome.
so much for having NAM present for the Long Island Hispanic Bar Association.
Thank you both. Thank you.
Thank you.
Have a
Alrighty,
good night.
bye now.